All right, thanks everyone for your patience. I think let's kick off this afternoon's So Now You Know series. Let me share my screen. All right, so let's get started. Thanks for joining us today. Let's just give a little bit of an introduction, although you may know who we are because you're here with us. Legalese is a creative legal agency. We have a goal to redesign the way in which legal services are rendered and provided. And with that in mind, we try and take creative solutions to address exactly what your company and business needs. In this instance, hopefully in attendance is our nonprofit sector. And because you are across industry, but you have a specific intention in your business, I think creative solutions and addressing those needs in a way that is tailored to exactly what they are, rather than just bulldozing through, is something that suits you guys very well. My name is Christian Tabor Rayside. I head the intellectual property department and head the legal team at Legalese. So that's why today I'm taking you through a lot of guidance and tips on how to protect your IP. You'll see that Legalese, we like to be a part of the community. We like to be a part of the journey of our clients. It isn't just about providing those services, it's also about the relationships that we get to build and getting to see clients go through the space that their business grows into. So what are we talking about today? Today, we're going to focus primarily on safe and effective methods for protecting your intellectual property. So don't get scared that I'm going to try and lecture the entire time and make you into a lawyer at the end of that. That is not the intention today. Don't worry. I went through the law degree so that you don't have to. Here we are today so that I can give you some tips, some practical ways to approach protecting your IP. Specifically, when you're a nonprofit, you might not have access to this type of knowledge behind intellectual property and the rights that you might have. So hopefully today you can walk away feeling more courageous about how to navigate your business because you understand the risks and gaps that you might have in your intellectual property, and in spaces where you don't understand and you need further assistance, where to go for assistance. So what are we going to cover specifically today? So I want to talk about the role of the lawyer. I think that's a practical way to kind of begin the discussion. People think the role of a lawyer is very specific to that of the television shows that portray us. We're more than that, a lot more than that. What I also want to talk about are who are the interested parties. That's kind of where we got to start this conversation when it comes to intellectual property. Who are the parties involved is going to be ground zero for you. The types of intellectual property. So what are the types? Well, we'll give some examples. We'll go through briefly patent and trademark. We'll go through design protections, but we're going to primarily focus on copyright today. So the effects of copyright, the various forms of copyright, exceptions in our copyright law, and then we're going to briefly touch on the nuance that happens with multiple jurisdictions. I'm sure many of you realize that we live in a global space, and a singular jurisdiction is not going to be an effective method to fully protect your IP. Obviously, you need to start somewhere, but having an understanding that multiple jurisdictions might be relevant is important. And then we're going to go through some frequently asked questions when it comes to contracts. You'll see that what we've discussed before are different types of protections that happen for your IP, but your contracts can also protect you. So we're going to talk about that, and we'll leave some space for questions, although I don't want to hold you here all afternoon. So you're always welcome to shoot me an email or someone from the team an email if you have some questions, and we're happy to engage you on that in that way. So what is the role of a lawyer? Coming from a lawyer, I guess it's quite biased, but I think it's important for us to discuss how best to engage with legal services and what their role should be in this instance. So our role is to view things as a composite whole. People may get isolated in a singular aspect of the circumstances or a singular aspect with regards to a dispute. We need to see things in a greater picture, a bigger picture, and hopefully that's the services that you get when you engage with a legal service provider. We facilitate conversations, right? So the conversations sometimes come in the form of a contract. Contracts are a form of conversation between two parties. We facilitate that not just by codifying it into the form of a contract and getting that in writing, but also by having those preliminary discussions to try and find where the compromise is and a meeting of the minds. We communicate the worst case scenario. I think a lot of our role deals with these next 2 points, the worst case scenario and the participation in a risk analysis. People need to know that worst case scenario. We end up being that person in the room sometimes that says, well, if it goes right, that's great. But if it goes wrong, this is what can happen. And it's important for us as lawyers to participate in that exercise, because then you as a business can make decisions knowing the risk, or at least a portion of what the risk could be. And then at the end, I've underlined this because I feel very personal about it. I think our role is also to educate. I think our role is to share as much knowledge as we can without trying to make you into a lawyer, but so that we can empower you to be more courageous with your business and more knowing about what the implications might be of certain actions when you choose to make them or when they arise. So who are the parties? The parties can be tons of different types of characters, right? You can have writers, you can have actors, you can have distributors, you can have, software developers, you can have the wallet, you can have the person who pays for all of these things to be developed. All of these people, all of these entities play different roles and hold different rights or have different expectations. So the exercise of trying to figure out who's who is very important. If we talk about what is the tip here that you need to make sure you start off with? Identifying who the creators are so that you can understand the variety of rights is going to be really important. Is there a license in place, right? That's an important one. Who holds the copyright? So is it the creator who then sold it off? So the person who purchased it now is the holder of the right and not the creator. It's not always very easy to identify who that individual is just from a certain set of facts. You need to follow the timeline and the movement of hands. You'll see things like brand affiliation. They might not own the IP, but they own a certain portion of the use of that IP, right? Which might be industry specific, it might be global, that they are the only ones who can affiliate themselves with it. You can see how this can get very messy if you don't pick apart and identify all the players involved. So let's talk about what those different types of intellectual property are. I mentioned that we're gonna touch on 4, but we're gonna focus primarily on copyright. You're gonna have your patents, you're gonna have trademarks, you're going to have your design protections, and you're going to have your copyright. I know that these terms may mean something for you in the way in which you've engaged with legal services previously, or in how Google has explained it to you, or maybe ChatGPT. But I just want to touch on what exactly it means specifically in this jurisdiction in South Africa. So a patent, it grants you an exclusive right for an invention, which is a product or a process that provides a new way of doing something or offers a new technical solution to a problem. Now, I emphasize new because that is essential to being able to get a patent in this instance. An individual patent application needs to be made in each country for the interested party seeking protection. So, when we talked earlier about multi-jurisdictional, maybe what you're doing is protecting right now here, but if you're going to get full protection, you might want to look at other jurisdictions to register a patent in those jurisdictions so that you get the protection. Protections in this regard are up to 20 years, which are renewed annually. But what I really want you to focus on in this instance is new ways of doing something or offering new technical solutions to a problem. These are the inventions that would then get a successful application with regards to patent and therefore be protected in this space. When you talk about trademarks, I want you to think about brand names. I want you to think about slogans, logos. It's about identity, right? A trademark identifies the services or goods of one person and distinguishes it from the services and goods of another. The classic example that everyone uses for this is Coca-Cola, right? Coca-Cola, I say it, you can picture it. You can picture the bottle, you can picture the label, you can picture the font. The brand identity there has been protected by way of trademark, and its protection being renewed over the years has allowed us to isolate it from all the other competitors. So similarly to patents, it gets renewed. However, this one's renewed every 10 years. Let's briefly talk about design. Design, similar to patents, very specific to exactly what you're referring to. Here we have kind of a breakdown of two types of designs that would get protection. One would be aesthetic designs and functional designs. Now, when it comes to aesthetic, it must be new and original, right? Similar to functional, it must be new, cannot be common, used elsewhere. But aesthetic has to do with beauty, so it's in its shape, configuration, ornamentation. I think the classic example in this space is going to be jewelry, right? So jewelry can be both functional and aesthetic insofar as the design may be unique. They have different protections that arise in this instance. Protections for aesthetic designs have 15 years and functional designs have 10. So let's talk about what we're going to spend more of our time on is copyright. So copyright is an exclusive right that's granted by law for a limited period to the author, designer, creator, etc. for their original work. In this instance, original, very important. And then I want you to focus also on creative, right? The creator. Unlike other forms of intellectual property, copyright does not require it to be registered, except specifically in this, when it comes to films. Protection generally is about 50 years. The lifespan of the protection is entirely dependent on the type of copyright. So we're going to talk about the different types of copyrights now. They're limited to those expressly stated in the legislation, and we'll get to that now. But let's talk about what the effect is, right? So what is the effect? So it grants the creator an exclusive right that vests automatically upon creation. Often I find myself discussing with clients, and we'll mention this later when we deal with protecting in terms of contract, is that they have a great idea, but that great idea is not one that gets protected by a copyright because it needs to manifest into a specific form. So the legislation itself tells you what those forms are, it categorizes them, and then it gives you the associated protection for that category. So the lifespan of protection is generally about 50 years, but as I mentioned, the type will dictate the protection, including when it commences. So upon when is that moment of manifesting an idea into form, and then when does it expire? But what does it keep people from doing? So if, for instance, you hold copyright, what are people not allowed to do? It's reproduce your work, it's publish your work, it's make adaptations of your work. In some instances, it's perform your work in public. Others, it's using that work in an unauthorized manner where you have not permitted it to be so. So we mentioned the different categories. Let's dive into what those are, right? The Copyright Act in South Africa sets a distinct category of 10 different types of copyrights. Now, we're not going to go into all of them in detail, but I just want to highlight, I think about 4. But what are those 10? Literary works, musical works, artistic works, photography, cinematography, sound recordings, broadcasts, program carrying signals, published editions, and computer programs. Now, if you think about your intellectual property, what it is that you're trying to protect, does it fall into any of these categories? If you aren't sure what these categories are, the legislation is fairly straightforward insofar as how it defines it. But sometimes, no matter how straightforward something is, it opens it up to interpretation, and you want to find out if you fall into that protection. So let's give an example of literary works, right? In this instance, who is the one that's protected? The author is the one that's protected, the individual who creates the literary work. The example here is novels, poems, written compositions. In this instance, it's the writing down of work that creates that protection. So literary work is protected from the time it is written down and for the duration of the owner's life plus 50 years after the death of the owner. So you can see it's not very straightforward to say generally 50 years of protection, because in this instance, when it comes to literary work, the writing down creates the moment for protection. The person holding the pen is the one who holds the rights, and it is protected for 50 years post their death. So let's talk about musical works. Who is protected in this instance? Well, the creator. But interestingly, with these, there's often works that have multiple contributors, collaborators. A band isn't a singular person playing an instrument. It's a group of people playing instruments collectively. So how are they participating in the creation of musical work? In those instances, there'll be contracts that deal specifically with the hiring of their services or the splitting of the rights. Musical compositions and songs would fall within this type of category. In this instance, it's from the moment it's written down, composed, or recorded that protection commences, and it's for the duration of the owner's life plus 50 years after the owner's death. Now remember, what is the first thing we do in instances with intellectual property? Identify who the parties are. Here we say owner's death, but we've already said that in this instance, owner could be a collective of people who are participating in the creation of it. And that is when you're going to need to unpick what could be quite chaotic, right? What is the relationship here? Were you all collectively doing this, or was Christian hiring you to assist him in creating this song? And therefore, Christian is the owner and you were the collaborators based on the contracts that you had or the agreements that you had with each other. You can see it can get a little messy. And now let's talk about artistic works. So photography. Photography is a really interesting one, right? Who gets protected here? It's the creator. The artistic works that would be included are paintings, drawings, photography, sculptures. Artistic works are protected from the creation by the owner for the duration of the owner's life, similar to the previous categories, for a 50-year period post their death as well. Photography is not from the snap of the photo, but it's from the development of the photograph for the duration of the owner's life plus the 50 years, right? The reason I say photography is interesting is because, I mean, in other instances, it's similar to fine art, paintings, drawings, sculptures. You may have a commission relationship. And we're going to talk about in the next section what those exceptions are. And a commissioning of work is an exception when it comes to who is the owner by default in our law. Finally, let's talk about sound recordings and films. So it's the person who the arrangement for the film or sound recordings were made. So I may be the engineer that's doing so, but the creator is the one who has hired me in that instance. Now we've talked kind of about the exception for copyright falling into the hands of the creator being a commission relationship. But in this particular category, it has already built in that exception or that nuance. Protection for film is for the period of 50 years from the date the film was shown in public. For sound recordings, it's from the date from which it was broadcast. Let's talk about those exceptions. So the first two, I think, are fairly common, but people don't always think of them. One has to do with the sale or contractual assignment of copyright. Copyright is something that is transferable through sale and assignment, right? It's this intangible right that we, as lawyers, have created a fictitious space of, and we sell it and assign it to individuals, so specific uses can be made. The owner becomes the person who accepts the sale or assignment and is no longer the original creator. So if we go back to me being the musician, I've made this music, but someone wants to own the music, so I sell my entire catalog to them. Even though I'm the creator, and by default became the right holder, I sold my rights off by way of a contract. And the only way in which you would know who the owner was is if you followed the timeline of that transaction from the creation of my IP to the sale of my IP. So let's talk about employment. Employment's a really interesting one because many of you might have people working in-house to develop intellectual property for your business. Intellectual property that your business runs on in its day-to-day space, and it is very vital for the success of your business, right? What's important here is the default space is that all work made in the course and scope of employment under a contract of service or apprenticeship is owned by the employer. So there may be instances where your employees have created an idea or something during the employment, and a dispute could arise that it happened during the course and scope of the employment, or it happened after hours at home. If, for instance, that IP has something to do with your own internal IP, there can be even more of a chaotic dispute that arises in who owns what. It's very important to ensure that these contracts in these two instances, these two examples, deal with intellectual property and that it's not omitted and that we have to play a game of interpretation about everyone's intention, right? The beauty of having things in writing, and I know that I'm quite biased because I'm a lawyer, the beauty of having it in writing is that when things go to worst case scenario, we can rely on the words and we don't have to interpret the emails, the WhatsApps, the conversations, because I can promise you from my experience, people get very creative with remembering what was said when a dispute arises. So finally, when it comes to exceptions, I want to talk about commissioned work because I think that's something that's going to happen quite often. You'll see here, I said a frequent example is that of a photograph, painting, drawing, film, sound recording. In this instance, I want you to, remember the default space is the creator, but the exception is the wallet. So if the creator has been hired to create something by another, it is upon payment of that service that the ownership transfers and does not automatically vest in that of the creator. So it's all just, let's bring that back. If, for instance, you're the creator who has been hired to create something and you haven't been paid, this would not apply, right? Because payment is required for ownership to transfer and not automatically vest. The last point I have here is about the use of the work, right? It may be limited by agreement between the parties. Why do I say that? If you think of photography, for instance, you have someone come and you hire them to take photos of your wedding, right? The agreement will result in you owning those photos, but it might be limited how you may use those photos. Perhaps you own a dress company and you want to show off the dresses or something that were in your wedding. You will need to agree that there can be commercial use of those photos. Often what ends up happening also is the photographer will retain the right to promotional use of those photos, right? So they can't sell them off to people as stock images, but what they may be able to do is continue to promote their own services by way of your own wedding. All right, so let's talk about multiple jurisdictions. This might not apply for a lot of you, but I think it's important for you to understand the nuance behind how intellectual property, specifically copyright, is dealt with outside of South Africa. The reason why it's dealt differently is because there is no international copyright law, right? It's territorial in the way that the protections are granted. And the reality is, in a global space and in the space that we currently live, often the infringements are extraterritorial, right? So while the rights remain very specific to the jurisdiction with which you created it and perhaps where you registered it, the infringement might happen on the other side of the planet. And it's important for you to understand that how it is dealt with there might be different than how it's dealt with here. So just briefly, let's talk about South Africa's protection. It's based specifically on categories for copyrights. And it's often, as you saw earlier, the life of an author, the life of a creator, plus a 50-year period. The UK deals with it with the life of the author or creator, plus a 70-year period. If, for instance, the author is unknown or the creator is unknown, the IP will have a 70-year automatic protection, but who holds that protection remains a mystery. When it comes to the US, it's the life of the author plus a 70-year period, similar to the UK. But then if we deal, just as an example about one specific difference, when it comes to literary work, it's a 95-year period from publication. So just to highlight how it can be different and how you mustn't just act as though it's all going to be treated exactly the same. If, for instance, you feel that there might be risk in a different jurisdiction, it would be in your best interest to at least have a basic knowledge as to what that risk would be. So I want to deal with some frequently asked questions when it comes to contracts and how you can protect your ideas and your IP in contracts. So what should you be looking out for when you deal with contracts? So I just have 5 pointers here. You need to look at the consideration of rights and how that matrix is incorporated in your contracts. Is there a worst case scenario situation dealt with? What I mean is the lawyer not pointing it out? I mean, if worst case scenario happens, how is it dealt with? Can you enforce your rights? Is there foresight considering when an instance of breach might occur and how you might be able to remedy such breach? How is intellectual property handled? So, if we go back to that photography discussion, where the photographer wants to hold it for promotional use, but you also have it for personal use, but then now you have a business and you're going to use it for your website to promote the dresses that you created. Is it actually acknowledged? Is it omitted? If it's omitted, then that's a problem, right? Because you don't want it to be something that everyone gets to remember creatively, right? And then is jurisdiction dealt with? So you'll find in contracts that often the jurisdiction that will govern the contract is expressly stated. The absence of that can be a mess. So I would highly recommend the parties agreeing to a specific jurisdiction. And if it's one that you're not familiar with, I would recommend you getting someone to assist you. The kind of theme between all of those pointers are these 3 points. And this is maybe, in my mind, one of the most useful ways to think of contract is, what do I get? So is it clear what I get? Is it accountable? So if I'm supposed to get something and I don't get it, how does it get dealt with? And can I find the ways in which they're failing to perform what I've requested? And then lastly, may I enforce it? How do I enforce it? Is there a method that's clearly set out for me to enforce it? So what are the types of contracts you should be looking at? You should be looking at pitching agreements, right? So if it's just your idea and you are shopping around for the best developers and you want to make sure that idea of yours is protected, before you get into that room, have everyone agree to a pitching agreement or a non-disclosure agreement. If, for instance, you've created something and you want to license it out for various uses, you should be looking at license agreements. In your existing agreements with your employees, with your freelancers, with your service providers, do you have confidentiality clauses? Are you dealing with intellectual property in those agreements? If not, you need to be. And then let's just briefly deal with what happens when you don't, right? What are the consequences? And we'll give a two-jurisdiction approach, and then we'll wrap. So in South Africa, a fine of up to 5,000 Rand can happen in the instances where there are infringements. Imprisonment in certain circumstances, up to 3 years could happen. A second conviction can lead to a 10,000 Rand fine and an imprisonment of up to 5 years. Beyond all of those consequences, you may find yourself in litigation where people interdict you. They send you cease and desist because of an infringement that you've caused. In the United States, it's punitive damages that are going to be dealt with, right? And it can be anywhere between $200,000 to $150,000 for each work that is infringed upon. Similarly, you might deal with things like interdicts, trying to prevent you from further infringement or compounded infringement. And then what might also happen is the work that is illegal can result in being impounded. Now, I think what I'm going to do is, instead of opening the space for questions, I'm going to let you contact us if you have any regarding your IP, if you have anything regarding the concepts that we discussed. I know the reality is what we have dealt with today is not something that is, entirely simple, and it may be something new for you. So please feel free to reach out if you have any questions. But I hope that today has left you feeling slightly more confident in this area of law and giving you a better understanding of what your rights are in that regard. So thanks so much for joining me today, and I hope you all have a great rest of your day, and we'll speak soon.